Well, hello everybody. Good morning, good afternoon, or good evening, depending wherever you are. It is a pleasure to be here today and chairing this session and to welcome you to the Europol Data Protection Experts Network, or EDEN. And this is an EDEN community webinar on lawful hacking within investigations of serious and organized crime. I'm Ian McAndrew and I'm the chairperson today. I'm the Dean of Doctoral Programs for Capital Technology University in America, where we specialize in a lot to do with cybersecurity and offensive cybersecurity. And this is my link to the area that we're dealing with today. But it is my pleasure to introduce a distinguished panel, and I will briefly cover each of them. Their resumes are amazing and everything, and will take an hour to cover justifiably. Dr. Jan Ellermann works as a senior specialist in Europol's data protection function and provides operational data protection related to guidance across the organization. He is passionate about data protection and is a key part of the EDEN that we are today. Dr. Mary Aiken is someone that is successful, and I was sitting at a train station looking at a television, and she was being interviewed live as I was sitting there. She has a global footprint. If you've not read any of her books, I would strongly encourage that. There are many things I could say about Dr. Mary, but I think one thing highlights her input, and that is she was made a Freeman of the City of Dublin. Now, this is a very prestigious title. We have Dr. Choi, who's from the University of Boston. He has established, or has an established track record of designing and delivering law enforcement training courses across a wide range of these areas, very influential in the academic side and supporting that from the practitioner. We have Dr. Alexandre Vautravers, a lieutenant colonel in the military, but associate fellow within the Global Fellowship Initiative of the GCSP Global Studies Institute at the University of Geneva. But he's not just limited to this university. Many other prestigious universities, and lectured widely across the world, and very interestingly in China and Iran, which not many people have. Professor Schafer, who is from the University of Edinburgh, a leading person in law, and looking at encompassing both the problems of technology and technology challenges related to law. And this is becoming even more important as technology expands in itself. And finally, Dr. Ilia, someone who is a cybersecurity expert and also a cyber law expert. And they will be the panel today doing a presentation, and we will try to answer questions from the audience, and if you could put them in the chat. I must have one caveat, and that is the views and expressions expressed here on an individual basis and do not represent any organization per se. Dr. Jan, may I hand the floor over to you, because I believe you have a brief presentation for us to start the session. Thank you.
Sure. Thank you very much for this nice introduction, and hello to everyone out there. My name is Jan Ellermann. I'm working as Senior Specialist in Europol's Data Protection Function, and my job is to advise the operational people. And indeed, I brought some slides for you. Let me try if I master the technology here. Share, go ahead like this and start from the beginning. So I hope this works. It looks like on my side, at least.
I can see it clearly.
Yeah, very good. Thank you very much. So welcome to this session on lawful hacking. As I'm a member of Europol's Data Protection Function, I'm working very closely with the operational colleagues here. And if I think about lawful hacking, one very practical example that many of you will have heard about most probably is EncroChat. And EncroChat was a service, a communication service, basically, which was used by serious crime networks. So an EncroChat device is not the kind of device you probably have in your pockets, but you had to pay 1,500 euros in order to get the device as such, and from then on also considerable amount per quarter, let's say, to maintain it. And all of that was just for a device which had close to zero functionality, but the providers argued that it would be bulletproof against law enforcement, and that attracted, as you can imagine, a lot of serious criminals. So in July 2020, this communication service was hacked by law enforcement, namely by French law enforcement, who collaborated closely with Dutch law enforcement. And at that point, we as Europol received the raw data set amounting to roughly 120 million messages. So that was a lot of data. And when we got this data, we tried to identify out of these mass communication as quickly as possible what we call threats to life. So what you see here on the screen right now is an original picture from the EncroChat dataset. So it is linked to a farmhouse which was raided by Dutch law enforcement here in the Netherlands. And it's a torture chamber, as you thought already. So this is what criminal groups provided for their opponents in particular. So this farmhouse had some shipping containers on them, and this is a soundproof cabin, let's say, which allows you to torture or also kill opponents. That gives you, let's say, an idea of what we looked at the time. EncroChat was huge, but not the biggest one. So it was followed in March 2021 by a takedown of Sky ECC, and Sky ECC was even bigger. We looked at 1 billion messages here. Because after EncroChat, let's say, many criminal groups also looked for a new home, and Sky ECC was one of them. So here we were confronted with a similar issue, or much bigger issue, in fact, to go through all these messages and provide law enforcement intelligence as quickly as possible. And the next operation, which is similar in nature, but there is an important difference, is Operation Greenlight. So Operation Greenlight, other than EncroChat and Sky ECC, was not an infrastructure run by or established for criminals, or in fact it was, because it was in fact an undercover operation run by the FBI in the US. So the FBI basically created its own encrypted communication service and then heavily promoted it amongst serious criminals via undercover agents. And that led to this ANOM service also being taken up by lots of organized crime groups to the benefit of law enforcement. Of course, you can imagine when EncroChat and Sky ECC went down, the FBI generously said, all the refugees are welcome. We have this amazing service here, which is called ANOM, of course, without revealing that it was run by the FBI at the time. What is a common denominator also from a data protection perspective here? In all these data sets, we were literally looking for the needle in the haystack, as you can imagine. So in order to identify something like this torture chair here, you have to read through millions literally of messages, and then you come across stuff like the quote from an original message, which you see there below. But you can all imagine that considering the magnitude of the information exchange, you cannot reasonably do that just by means of human intelligence. You have to use artificial intelligence. Here on the screen, you see now use cases of AI in the private sector, or known cases, but maybe the less known cases are the kind of cases we use in law enforcement. So we have machine learning tools. We use machine translation to automatically translate text messages into English. For instance, there are also other use cases of natural language processing. So for those of you who are not intimately familiar, that means basically that an algorithm is going in an automated fashion through all these messages and trying to identify, let's say, entities such as license plates or an address. And that allows us, for analysts, to get much quicker to where they need to be in order to analyze stuff. Another use case would be image classification. So for instance, you can imagine if your task is to identify threats to life, you're very much interested in all the pictures in these mass data sets which show weapons or drugs, for instance. But the most important thing from a data protection perspective probably is, even if you use AI in a law enforcement context, and even if it makes a lot of sense to use it, certainly at the very end of the chain, there needs to be human validation, so a human intervention. So we never leave the decision on whether something is acted upon to the machines, but the machines, let's say, try to reduce the workload in a sense that there are suggestions on what an analyst, a human being, should be looking at first. However, of course, there is a lot of concern surrounding artificial intelligence, including use of machine learning out there. And the same, or even more so, this is true for law enforcement. And this is why this slide here with a ugly muscled man, let's make him disappear better. But that is just a visual to say, at Europol, we are not alone. We cannot do what we want with the data. Basically, we are closely supervised by data protection authorities as law enforcement. In the case of Europol, that's the European Data Protection Supervisor. And the European Data Protection Supervisor has quite some muscle power, as you just saw. I always call it the nuclear weapon they can pull is issue a processing ban. So when they consider what we do is not proportionate or not necessary for the purpose for which we are doing it, they will simply pull our plug. So to conclude my brief presentation, and I'm sure there are going to be a lot of questions out there, lawful hacking has to be seen in the broader context. There are a lot of ethical, but also data protection related questions, including that of the use of AI, because sometimes we talk about huge amounts of data. But I'm happy to expand and to elaborate in more depth if this is of interest for the audience, to provide some reassurance that we cannot do this in a vacuum or behind the curtains, but that we are subject to quite sophisticated checks and balances, model supervision, external supervision. And if there are questions, happy to try to answer them. My last word for now is this event here is part of the Europol Data Protection Experts Network. So it's an Eden community event. And I would in particular like to thank Ilia once again, who really invested a lot of work here. If you like this kind of talk, there's going to be more, and you can join us in Madrid, 18th and 19th of September. There's the next Eden conference. It's a live event, basically, so you can enjoy these kind of talks under the sun of Madrid, and you're going to find all the related information on Europol's website and on the website of the ERA, the European Law Academy. That's all for it from my side. Now, thank you very much.
Thank you very much, Dr. Jain. That was a very good summary and introduction. I think it leads very nicely into Dr. Vautravers as the French link starting to unravel this problem as introduced there. And Dr. Alexandre, may I introduce you for your input and reflections, please? Thank you.
Of course, my pleasure. As I said, I will be very brief and look more at the political and strategic aspects than some of the things that we can definitely build upon. Thank you very much for your presentation, and thank you very much for your hospitality and the organization of this event. Very roughly, Switzerland is a special case, and it's a special case because of a specific event that happened in the mid-1990s, which essentially pulled the plug on Switzerland's intelligence services. And by that, I mean everything from military to police intelligence to all sorts of other aspects. And this particular sour political history explains that until 2015, Switzerland's capabilities in the area of cybercrime or listening in to various devices was extremely limited. In fact, it was so limited that we had to be extremely creative. And so instead of having a government, a federal government agency in charge of consolidating the actions and developing a strategy. The only thing pretty much that the federal government could do was pay the salaries of cantonal or state employees that would, of course, benefit from much more, how should I say, deeper and more effective laws than anything that was available at the federal level. So we have a very backward case, and I think that what we are doing right now is we're essentially trying to catch up. 2015, as I said, created a lot of opportunities with a popular vote in favor of a new intelligence law, which basically provides a certain number of cases, originally 4, now 5 different cases. So terrorism, violent extremism, this was the politically contentious item, the trafficking of weapons of mass destruction, unauthorized intelligence activities, and protection of critical infrastructure. And as you know, this can mean a lot of different things. But anyway, this law came into force in 2016, and this is the major basis for our actions today. And this has, I think, allowed to catch up quite a lot of the challenges that we have had. We've now gone through 2 consecutive cyber strategies. For the purpose of our discussion here, I will say that what has come out of this is a very clear distinction between what is of a strategic nature, strategic threats, and that's basically federal government, the Federal Office of the Police, and then everything else, cyber crime. So what we are essentially talking about is essentially the responsibility of the various cantons or the various governments. For this reason, we have in the French-speaking part of Switzerland put together a regional cooperation center on cyber issues. It's called RC3, and we have built upon the forensics that we are quite reputable for in the past few years. What has come out of this? We can say that the numbers are not looking very, very good. We have witnessed last year, these are the public numbers, 33,345 cyber crimes that have been reported to the police within the whole of the country, the whole of Switzerland. This is an increase of 34.5% from last year. But unfortunately, if we're looking at economic cybercrime, this is an augmentation of 61% from one year to the next. So we're definitely not where we want to be. And this is today where most of the strategic priorities are going: protection of critical infrastructures, from hospitals to government organizations to large and medium corporations. And the police, of course, the local police are responsible for cyber crime and sort of lower intensity issues. What this has produced is we have had to slow down digital voting in Switzerland because of these particular issues. There have been popular sentences, so votes against going further in the direction of digital voting. With regards to healthcare and the transmission of data from hospital to hospital, this has also been essentially slowed down, and we're waiting for a number of breakthroughs before we are able to get back and continue moving forward with these issues. And there was a very strong lobby and initiative to reduce the amount of cash use in Switzerland, and this is also something that has been substantially slowed down. Of course, the recent year-long problematic of energy scarcity and critical networks, critical energy networks, was also slowed all of this down. So this is where we stand today. I believe that there's a good job that is being done with regards to personal, individual users. I think on the strategic level, we have built up a capacity, and the military has been funding quite a lot of effort in training on these particular issues. As I said, we're probably waiting for a number of technical breakthroughs before we can move forward and actually catch up where we and reach the status of where we want to be. Thank you.
Thank you very much. Very insightful. And I think this leads perfectly into yourself, Professor Schafer, as we're overarching here with the legal aspect. And if I could hand to you, sir.
Yeah, thanks a lot. I mean, that was already quite fascinating, especially Jan's presentation. And obviously, who could not want these people to be brought to justice? So a very efficient lead. And don't get me wrong, I'm strongly in favor of lawful hacking when it is done properly. But that is a big bit. But Germany introduced the Bundestrojaner, the federal Trojan, back in 2011. That led to litigation at the Constitutional Court. There are still 3 cases pending as we speak at the moment, trying to align these measures with constitutional demands, not just of privacy, but also fair trial. So quite a lot of unsettled territory still to deal with. And one of the things, and that might be slightly problematic, obviously, in the Eden context, from my perspective, a certain worry that we treat data protection law as the final arbiter, as if as long as we can deal with data protection problems, everything will be fine. And to a certain extent, that is even the position that the German Constitutional Court took. It created a new fundamental right in the integrity of information systems, but that was in a way an extension of data protection law. What was much less discussed were other impact it has on fair trial, concepts of state sovereignty in internet, and also the rights of the citizen vis-a-vis the police. So my first point in a way would be to say, and as I said, this is a slightly paradoxical point to make to data protection experts, don't try to do it on your own. There are other legal fields that are just as important. And I think in the European context, we very quickly also face here a certain difficulty. Data protection law obviously is harmonized. We have the General Data Protection Regulation, we have the Police Directive, even more important for what we are discussing here. So there is, to a certain extent, a overarching regulatory framework. Police procedure and evidence law, by contrast, is massively devolved. There's relatively little harmonization. States are still very, very protective of the rules and procedures. But we also know that these rules of evidence and procedure very often have been used to indirectly protect data protection and privacy. So the exclusionary rules, in particular in common law-based jurisdiction, suppression of evidence for you, Ian, Fourth Amendment case law that says, okay, there are things the police mustn't do, but the consequences very often are then in the trial and in the way that evidence can be used. So I think we have here a certain dilemma, I would say, that while on the one hand, we have the rules of data protection that apply to the police in a harmonized way, quite a lot of the, if you like, the enforcement of data protection against the police is devolved to individual nation states. And that brings me to the next point, where I think Jan's presentation was interesting, and I would have lots and lots of questions offline on him. But obviously, the investigations that he described were in the context of Europol and official state collaboration. The police forces of the Netherlands and France knew what they were doing. They were collaborating intentionally. And that is fine because we have rules for that. Europol has rules for that. And as long as it is in that sort of institutional framework, quite a lot of my concerns would be taken care of. But what happens if a national police force hacks into compromise a mobile communication equipment that is then moved by its owner across national borders, which de facto and without that type of official collaboration gives access across jurisdictions? Now, I'm old, as you can see. I don't have my ponytail any longer. I remember my first European Cup. That was back in 1988. Germany was the host. And there was a huge discussion on whether British police officers should be allowed to travel with football hooligans and provide intelligence for the German police. And by and large, that was deemed totally unacceptable. Foreign police in uniform exercising sovereign powers on the territory of another state, anathema, even for something as relatively trivial as saying, oh yeah, that guy, have an eye out for him, he's a known hooligan. So in the physical space, states are massively protective here. And there was the old adage, if it is prohibited offline, it should also be prohibited online. But online we now face this potential situation of quite significant exercise of sovereign power on machines and citizens across your own border. And that, it doesn't worry me, but I do think there needs to be a legal framework for that. A framework that determines also what rules of evidence apply. The one on the territory where the machine is placed, the one where the server is placed, the one where the police officer sits. For the citizen, that might make huge differences. Again, in terms of suppression of evidence, of rules of procedure. And these, as I said, are indirectly enhancing data protection law. Another set of questions that I would have, and we might discuss later on in this context, which are not primarily data protection questions, is if you take as a physical world equivalent the traditional search of premises. Yeah, we have rules for that. And some of these rules also govern with what my remedies as a citizen are if afterwards something went wrong. If the police breaks into my flat with a warrant in Germany and destroys the lock in the process, they have to pay for it. Very unlike, I know, the American indemnity for federal police officers, but here the state has to make good any damage that is caused. What's the situation here? If this happens virtually on a computer, how do I quantify it? How do I even know as a citizen that my machine might not be quite as good now than it was before? So we have to think about what are here the remedies. Similarly, if a police officer with a warrant knocks at my door, what I shouldn't do is slam the door in his face. Bad strategy. Shooting at the officer, definitely not on. What is the equivalent for a lawful online hack? What are my rights as a citizen to protect me against this? At which point do I start to interfere illegally with a police operation simply by using, for instance, maybe hackbacks or other more harmless countermeasures? So for me, lawful hacking is needed. As the Constitutional Court in Germany ruled in 2011, it requires an explicit legal framework. From what I see at the moment, we have paid maybe too much attention of formal requirements here, warrant, who signs it, who acts at the preliminary stage, and too much almost on the data protection side. We've omitted, I think, to have clear and similar rules for a host of other issues that hacking raises. And I would like to see, also on the European level, harmonization in that field and simply clear rules that tell me as citizens what is a law that applies here in terms of the evidence, in terms of oppression of the evidence, in terms of getting damages, in terms of challenging the police behavior or defend myself against that. So that would be my position. As long as Europe does it within a clear legal framework, much less concern national police forces suddenly investigating abroad, I think that raises a lot of interesting and important questions to which we don't have the answers yet.
Thank you very much, Professor, which I think it leads perfectly into Dr. Choi, who's going to be talking as his expertise in not only the academic and legal side, but also supporting law enforcement and the education of those. So, Doctor, the floor is yours now.
Thank you. Yeah, I'm a pro of lawful hacking by law enforcement. In the United States, there is no detailed piece of US legislation specifically kind of regulating the use of hacking by law enforcement. However, specific kind of legal framework for hacking by law enforcement is kind of one of the agenda for discussion at bipartisan encryption working group of the US Congress. So I think you try to tie with Dr. Ellermann's kind of case. So another great case like Operation Pacifier. So between kind of late February and early kind of March of 2015, Operation Pacifier, activated as a FBI, spent this kind of 2-week period secretly kind of hosting one of the most notorious kind of dark webs, Playpen, hosting CSAM, child sexual abuse material. So the website owner was sentenced 30 years in prison, and then administrator sentence kind of 20 years. So, the problem, many people kind of argue through the kind of process kind of referred to as a network investigative technique, that's a NIT. The FBI was able to install such warrant permitted malicious software onto visitors' computer as they kind of log on to particular, the forum where child pornography was kind of posted. So NIT software kind of relayed identifying information back to FBI, allowing investigators to track their use of kind of the IP addresses, and ultimately kind of through administrative kind of subpoena and their location. So the FBI extended search warrants at the Playpen website visitors, residents, or point of access, to kind of further investigate, this criminal behavior. So May of 2017, Operation Pacifier has kind of resulted in arrest of kind of over 800 children pornography consumers, and 51 whom were found to be kind of hands-on offenders. So most importantly, this operation led to the result of 55 children who were identified as a victim of contact offenses and exploitation. So, of course, there's a lot of challenges, United States versus 11, and the defendant claimed NIT search warrant was defective because the defendant believed lacked the authority to issue to search a computer located in Massachusetts. In December of 2016, Congress approved changes to Federal Rule 41B, which now authorizes magistrate to issue search warrants where a suspect has hidden the location of his or her computer using technological means, even if that falls outside of the magistrate geographical jurisdiction. So on August 28, 2019, 11th Circuit Court of Appeal ruled the warrant was invalid, but the evidence obtained was not required to be excluded due to good faith exception doctrine. So, as of kind of today, if I remember correctly, there's a 46 Operation Pacifier defendants had plead guilty or had been kind of found guilty after trial. To me, it depends on the cases, right? And so we really have to consider the gravity of crime. I think it's like organized crime, and this type of sexual crime is a serious crime. And so if we don't give out the kind of power to hack, I don't know, the bad guys, right? And so how we really kind of deter the crime. So I think that's my standpoint. And at the same time, definitely certain guidelines, right? Evaluation and monitoring activities on the kind of, the practical application of, the law enforcement kind of guideline must be kind of provided from the government side, and also kind of working with the multiple jurisdiction, meaning like working with the kind of Europol and Interpol. And then, we need to have some type of consensus kind of, the lawful hacking guideline for sure. Thank you.
Thank you very much, Doctor. That's fascinating to listen to, and it's a very good sort of summary on what has been spoken before and practical implications. But now I'd like to introduce Dr. Mary at this stage, because Dr. Mary brings in this cyber psychology side of it, where she's not focused on cyber security, if I'm not paraphrasing you incorrectly, Dr. Mary, but not focusing on the clinical psychology side, but looking at this new area and an emerging area of cyber psychology, of where this comes together in terms of, well, I'm not going to go into it because I'll leave this to you, but it frightened me when I heard her talk about passwords, because I thought I was good at it. But I will hand over to you now, Dr. Mary.
Thanks, Ian. So, yes, I'm a professor of cyber psychology at UAL in London and at CapTech. And just for transparency, before I give my opinion, I'm also an academic advisor to Europol, to the EC3 Cybercrime Centre, and also a member of the Interpol Cybercrime Expert Group. So to start off, yes, I'm in favor of lawful hacking within investigations of serious and organized crime. However, hacking not just of systems, but of human offenders. This is going to get the privacy people on edge. I think that, winding back a little, what we've got to do is, first of all, we have to wind back to that symbiotic relationship between the real world and cyberspace and the interaction between the two. And I think that what we're doing is we're taking real world policing and then we're trying to transpose it to cyberspace. And that's really difficult, because effectively we're talking about a very, very different domain. And I think that's why we're losing the battle. I think that, I recently co-authored a paper with Dr. Ellermann for Europol, and it was titled The Cyber Blue Line. And the cyber blue line comes from a metaphor, which was a thin red line, which was the Battle of Balaclava, which is a metaphor for a thinly stretched resource, which was the Scottish Regiment, trying to meet overwhelming force, which was the charge of the Russian cavalry. But that cavalry charge is now taking place in cyberspace, and you've got this thinly stretched resource trying to meet overwhelming force. And therein lies the problem. The point is, when we talk about cyber attacks, well, cybercrime specifically, and then cyber attacks as a subset of that, what we're talking about is a big data problem in terms of volume, velocity, and variety. So we cannot tackle this without AI and ML solutions. I think part of the problem is that to date, the discussions of how to do with exponentially increasing cybercriminality is that we've been focusing on data, almost exclusively on data. Now, the point about cybersecurity, we've had 60 odd years of cybersecurity, and it protects your data, your systems, and your networks, but it does not protect what it is to be human online. And it does not readily identify what it is to be a cyber threat, a cyber offender, a cyber perpetrator online. And I think essentially for me, that is the problem space. And, your data is never going to have the need for revenge. Your data is never going to have vulnerability in terms of suffering from low self-esteem. So I think there are a couple of paradigm shifts here that we need to actually conceptualize in order to be able to tackle these problems effectively. And what we see is this growing area of online safety regulation, which is attempting to factor in what it is to be human online and factor humans into the cybersecurity equation. I'm involved with a US research project at the moment. It's a call for proposals from IARPA, which is called Rescind. And effectively, that project is looking at reimagining security with cyber psychology-informed network defenses. So what is that? The focus is on hacking the cognitive process of cyber attackers. So again, from an investigative point of view, think about going beyond the data and hacking into offender decision-making, cognitive vulnerabilities, and switching in that regard. So, and again, it pulls, I suppose, the focus to prevention and deterrence rather than investigation after the fact. Now, of course, there are all sorts of debates about the legality of such activities. In the US, it does not need special authorization or permission in this form. Europe will be different by jurisdiction. Just to wrap up, we've recently completed a Horizon 2020 project on human and technical drivers of cybercrime, where we looked at cyber juvenile delinquency and applying theory of planned behavior, which is an intention to hack, and looking at scientific points of intervention. We also looked at investigating evidence in terms of forensic evidence that could be captured as a result of a cyber attack, and looking at interpreting that in a behavioral context. So, for example, arguably the connectivity between malware of choice and the behavioral characteristics of the offender. So you might hypothesize that those who deploy ransomware would be high on the dark tetrad scale in terms of psychopathic traits, and therefore from an investigative and indeed intervention point of view, it provides some information in terms of how you might tackle that. But just to wrap up, I think that what we've got to consider as an overview that, you know, in an age of technology, we have three aims. We have, of course, an aim of privacy from a citizen point of view. We also, however, have an aim of collective security from a societal and LEA perspective. And then we have an aim of the vitality of the tech sector in terms of we want these continuous evolutions. However, none of those aims should have primacy over the other. And the point at which privacy begins to trump collective security, well, we're going to be in trouble.
Thank you, Dr. Berry. Very insightful. And finally, if I may introduce Dr. Ilia for your perspective as someone we would describe as a cyber expert and highly educated law aspect of this, for your observations, please.
Thank you. I'll probably share my concern about the growing sophistication of cybercrime. And I'm not talking about ChatGPT because I personally believe that ChatGPT will not create a significant shift in cybercrime. Generative AI may and probably will certainly accelerate certain types of online fraud and scam, but it will not be a revolution. I'm talking about specific activities of sophisticated, I'll call them organized cybercrime groups that are now starting to conduct what usually have been performed by law enforcement agencies. For example, now different places, I'm not talking about publicly accessible or semi-publicly accessible forums or chats in the dark web, where sophisticated cyber criminals are buying and selling stolen data, trade secrets, different classified documents from the governments. They try to preserve utmost secrecy. And they know that law enforcement agency and also private companies are chasing them. So now they started to sell anti-law enforcement threat intelligence, meaning that cyber criminals are collecting information about potential agents of law enforcement and cybersecurity companies, tracking their IP addresses, tracking their nicknames, tracking their communication style. Just this morning, I received an interesting report from our team at ImmuniWeb saying that apparently, a cyber crime group has retained a psychologist to detect in a proactive manner whether a person that is trying to enter into a restricted marketplace, stolen goods, is coming from law enforcement. How? Usually law enforcement officers, at least in some countries, they are trained by specific instructors and they are following specific scripts, what to say, what not to say. And also by different habits. I'm not an expert at all in psychology, but I know that in addition to collecting technical evidence that can be easily changed or falsified, now cyber criminals are trying to collect, I would say, human evidence to effectively spot law enforcement agents when they're trying to infiltrate into their criminal networks. And also, what we understand is that frequently, once they detect with reasonable certainty a law enforcement agent, cyber criminals will not immediately ban him or her. They would rather keep him or her and control its activities just to make sure that they understand what law enforcement agencies are planning, what they are trying to achieve, what are their methodologies, what kind of materials they are trying to acquire, what kind of evidence they are trying to collect. So we observe growing sophistication, I'd say growing maturity of cybercrime, and this is really an alarming trend because practically speaking, to build a perfectly, I would say, not unhackable, but rather uninvestigatable online community, you don't really need, to perform any illicit activities. You can lawfully purchase your virtual infrastructure at Google Cloud, at Amazon. You can implement perfect, strong encryption by default and by design. So even if you have, warrant, you have, physical, practical, and legal capabilities to seize the data, it will be a brick. So basically speaking, with the growing sophistication and wide accessibility of online services, for storage and online communications that are easily available to anyone, investigation of cybercrime and internet-enabled crime becomes an arduous task. And also we can see that cyber criminals now, they are becoming smart, they're becoming intelligent, they're becoming organized. And I believe that this will be a big challenge for law enforcement agencies for the next decade.
Thank you. We have some fascinating questions in the chat, and I'd like to put some of these out to you as the panel. And for those of you who have asked some questions, if I don't get to them, please accept my apology, because we are limited with time. Let's just start with a very simple one, and this is for Dr. Yan, really. And it says, I'm unfamiliar, this is from Sean, I'm unfamiliar with the EncroChat. I see that they were selling modified phones. When I take a look, is there a service provider as well? Now, I know that's a general question, but I think this is something which some people will find fascinating. So, Dr. Jan, could you sort of briefly answer that one?
Yeah, EncroChat was a company which was, let's say, advertising themselves as a legitimate business enterprise for people who are interested in enhanced privacy communication solutions. But ultimately, if you looked at their services in a bit more depth, their target audience was clearly organized criminal networks only, because in order to purchase an EncroChat device, you could also not just walk into any shop and ask like for a Vodafone provider or O2 or something like this, but you really had to be recommended via mouth propaganda, and then basically you would be handed out a distinct device which was running, let's say, the EncroChat communication software. So it was both. It was modified phones basically running the EncroChat software, but these phones were stripped, so you could not install any apps whatsoever. You could only communicate with other individuals who also had the EncroChat phones as such. So while when French and Dutch law enforcement, let's say, managed to infiltrate this network and do the lawful hacking, there was quite some heated debate in the privacy bubble, because the assumption was that only a part of users would be criminals, and quite some users, also legitimate users, with just an enhanced desire for privacy. Our observation as law enforcement is that really the overwhelming majority of EncroChat users was indeed part of a criminal network, so that ultimately also the providers as such, or the business enterprise, was considered as a criminal organization by French law enforcement.
Thank you very much. I have another question here from an anonymous attendee, and I think this is directly to yourself, Professor Schafer. But if anyone else wants to answer after it, it says, my question is simple. Is the physical world analogy not a dangerous path? As for example, some people say a private mobile phone is an extension of the self, more so private then than a cupboard in someone's apartment. Do you have a view? If you could share your view on that, please, Professor.
I totally agree. These analogies are massively dangerous. Unfortunately, they are also inevitable because they are the way we as decision makers make sense of something as abstract as cyberspace technology. And that is obviously particularly true if you have a legal system that has lay participation, jury trials in one form or the other. But it's also, I would say, true of judges, lawyers who are not technology experts. I would even say it's true of technologists as well. We make sense of the world through analogies to things we know. And yes, they are dangerous. We need to check them. We need to think about their appropriateness. The point for me in this context, though, was that the adage that just by going online, behavior doesn't suddenly become legal when it was otherwise illegal, also should apply to police and police investigation. We use it as a benchmark, as a principle for criminal law. We should also use it as a benchmark for police procedure, I would say. So we are forced by the law, I would, in that sense, argue, also to make these analogies to ensure that protection that we want to have, where as a democratic parliament has acted and prescribed certain rights, that they are not eroded simply because investigation moves online.
Thank you. Does anyone else on the panel have any observations or comments that they'd like to Mary?
Yeah, I think this is the crux of the problem, is that what we have to factor in, that in terms of cyber psychology, is that human behavior fundamentally mutates or changes online. So you have powerful drivers, such as the power of anonymity, which you actually don't have or can't have as a real world construct. It is a superhuman power of invisibility. And we have to factor that into process in terms of how we describe these constructs and how we legislate for them and how we prosecute. Because again, it comes back to the point that I was making, is that we're trying to describe cyberspace and legislate for cyberspace in terms of real world constructs, when in fact we're talking about a very, very different environment, the environment of cyberspace, and hence the complexity.
Thank you. Is anyone else, or we can move on to another question?
Well, if you allow, I just briefly.
Oh, absolutely.
I just briefly also wanted to come back to one interesting remark which Professor Schafer made earlier. Basically, the assumption that if we are fine from a data protection perspective, all is fine. And that maybe these days, sometimes then the right to fair trial, for instance, is overlooked. I see that as well. It's an interesting debate ongoing in the member state, but you also see countermeasures and developments, including at the EU level already. So if you take the example of Europol with the latest legislative reform, we got from now on, since last summer, basically, we do not only have a data protection officer, but at Europol also a fundamental rights officer, which is interesting to note, considering that we don't have coercive powers. But that is an acknowledgement by the legislator to say, even if you don't click handcuffs and even if you guys don't carry firearms, what you are doing can very well have an effect beyond the fundamental right to data protection. And in this context, I also wanted to mention then that Europol is closely collaborating not only with the EDPS, but also with the Fundamental Rights Agency, for instance. And then Professor Schafer, there is one interesting article I've come across by your colleague Jan-Jaap Olemans, who is professor at Utrecht University, who basically looked at the question whether what the Dutch did with the EncroChat qualifies as an infringement of the fundamental rights to a fair trial. And he comes to the conclusion that considering all the safeguards which were applied, he at least is of the opinion it would not be the case, which of course was encouraging from a law enforcement perspective. Yeah. Thank you.
Excellent. I said I knew about that new post, and that was exactly what I said. That's needed. So again, very much in favor of the Europol approach. If I can quickly answer to a really interesting point Mary was raising here, the issue of anonymity, because again we have here a strong and quite convincing narrative that says here in cyberspace people are anonymous. That changes their behavior. That changes the way they interact. That's why we shout on Twitter at each other in ways that would be totally unacceptable in real world. Absolutely true. But what I find much, much less is, again, that insight applied to policing. If I interact with a physical police officer, they have their name very often written on their uniform. I can deduce from their uniform which police force they belong to, what rank they have. I know whom to complain to when I'm unhappy with the interaction. How does that translate? How do these rights that I have as a citizen translate now in the anonymity that we have online, where I might not know if a interference with my equipment comes from the police, from a criminal, which police force it comes from, if I think it is the police. So I think the anonymity argument is really interesting, but again, it works in both directions, not just in the anonymity of the target, if you like.
And not just about law enforcement and not just about offenders. We also have to factor in social tech also in terms of surveillance. So there are lots of parties we should be concerned about in terms of anonymity online.
Well, very quickly, Dr. Alexandre, ask for your observation, because I know you're on a tight schedule when you've only got a minute. But if you talk about that comment about identifying yourself in a capacity, because I know you're a very senior officer, your quick observation on that, please.
There have been many discussions, and essentially the new police laws throughout Switzerland have actually provided avenues to these solutions. So anonymity is a given for inquiries, and this was not the case before 2015. We changed the laws.
Thank you very much. It is now more or less 1 hour, so technically we have reached the end, and I know some of our distinguished guests here have very pressing other meetings. As you can imagine, they're highly in demand. And for those that have to leave, I thank you for your time. But so as we slowly wind it down, we won't cut it off exactly. I think there's an excellent question, Dr. Chow. I think this goes to you. How does the fear of surpassing jurisdiction tie into FBI investigations overseas using evidence through hacking groups? And I think it's perfect for you to address.
So that question for me?
Please.
Okay. So how do they oversee? I don't think I can kind of share all the detailed technical skill set, but as mentioned, yeah, there are lots of kind of, the lawful hacking tools and the law enforcement develop, and we closely working with academics and scientists. So there are dedicated the technique and tools available to only law enforcement. And that's how we definitely kind of investigate, that's why we don't have a kind of very specific kind of legal boundary. And for lawful hacking at this moment, as mentioned, I think everybody kind of trying to create a kind of very clear and precise legal base for use of hacking techniques, and even like we are developing kind of practitioner handbook and lots of kind of things that we do. So I wonder if I answered that question and how we oversee.
No, that's fine. I mean, it's a very big question. You could have a whole seminar on that one particular question and different things. But if we sort of try to pull this together as we come down, and just an observation from myself, we're all familiar with the old films where the wife who knows the guilt of her husband cannot give evidence in court. And I always wonder how this is going to encroach on the law enforcement and the people that work hard to keep us safe, where these types of new angles that very clever lawyers understand the law can put forward. And I'd also like to bear in mind something I heard from Dr. Mary a little while ago. We're taught to do many, many things, but we don't teach even the children nowadays to learn how to use technology. We may teach them how it works, but we don't teach them how we would do it. Like most of us, if we went to an auntie's house, our parents would tell us, you don't do this in front of your auntie, or different things. And if we expand that into the situation, and of course, then you have the cultural hierarchy of how communications had happened, which just goes to further compound all of that. And I don't know if Dr. Mary and then Dr. Ilia, if you could have an input on that as well, please.
Yeah, I mean, certainly part of the well, the elephant in the cyber room is really the topography of the internet, the surface web, and then the deep web, and what's happening in the dark web. And nobody really wants to discuss that. The reason we have rampant cyber criminality is because these are offender convergence settings. Offender convergence settings back in the day were the local pub where you gathered to talk about, let's, burgle that house. But now these are syndicated online, and within 2 clicks, you can find like-minded cohorts to engage in criminality. Also, the barrier for entry to cybercrime has been significantly lowered. Why? Because you don't have to have the technical skills to engage in cybercrime. Now you can buy an exploit, rent an exploit, or hire somebody to do it for you. So this is going to exponentially drive cybercriminality. And while we worry about while policymakers worry about all the restrictions they can place on law enforcement, nobody is addressing, well, who's going to police? Who is going to handle this, tsunami of criminality that is coming at us? So back in 2004, John Suller wrote about the minimization of and status of authority online. So when you have young people growing up in cyberspace, effectively, if there is a perception that nobody is in charge, then you will get increasing what we describe as cyber feral behavior and juvenile cyber delinquency. So we have this mentality of us over here as good citizens and cyber criminals and offenders over there. Our recent survey through the Horizon 2020 project, we interviewed in the CC Driver project into human and technical drivers of cybercrime. We did the largest ever EU-funded study of youth, 8,000 16 to 19-year-olds. And we did a very complex questionnaire, a 40-minute questionnaire. And we found that almost 50% of those interviewed admitted to engaging in at least one form of cybercrime in the previous year. This is catastrophic. This is young people actively engaging in money muling, actively engaging in cyber fraud, actively engaging in identity theft. Because to your point, Ian, we're not raising children to understand what is right, what is wrong, what they should do. We have generations now of virtual shoplifters growing up with, hacked movies, hacked music, crack software. The moral compass is different, and that is problematic for society.
Thank you. Very, very insightful. And Dr. Ilia, if I could finally ask you how you see the two are bridged, because this is part of your work on the commercial side, not just the legal side and the crime side.
So from my side, I would probably say that what can be really beneficial is to invest into training of judges, because law enforcement agencies, they usually have some modest capacities to invest into technical training. Though I believe that we certainly need to increase law enforcement budgets dedicated to cybercrime investigation and prosecution, because compared to the huge problem of cybercrime, I believe that virtually all Western agencies in charge of preventing, investigating, and prosecuting cyber or online crime are significantly underfunded. Okay, and it is also a challenge for them to hire talent, because private companies can pay them significantly higher salaries. Cyber criminals can offer, salaries that probably an honest law enforcement officer will get in 5 years of work. So I believe that we certainly need to increase funding, but not only of law enforcement officers, because they have, I would say, comparatively good level of technical training, but judges probably is one of the biggest challenge, because frequently we have very experienced, very wise people who are serving as judges, but they lack technical training. And especially in common law jurisdictions where judges can make law in some cases, we see a lot of wisdom when dealing with new technologies like automobiles or airplanes, But with cybersecurity, things are so complicated that when the judge receives a request, for example, from law enforcement to approve an intrusive online hacking operation, many of them will have more questions than answers. Also, frequently when dealing with admissibility of evidence, when dealing with legality of certain regulations or legislation, judges need to have more technical education. So I believe all countries should implement like a mandatory program to train the judges about cybersecurity, about capabilities that cyber criminals have, because it will significantly accelerate certain processes when judge is supposed to address a question of law and apply law to certain facts. And I believe that investment of governmental budget into training of judicial branch of government will bring a lot of good results.
Ilia, probably we could develop a chatbot that the judges could interact with, a very well-designed one, which would actually give them good feedback and Q&A and, maybe a more less technical explanation of what's at stake.
That's a great idea, Professor. And I think that, generative AI can bring a lot of value, in assisting judges, prosecutors as well. Probably not to make the judgments, because then we'll go too far, but as an intelligent assistant, certainly yes.
Yeah, we've seen problems with bias in terms of AI used for sentencing purposes. However, I think it could be a very valuable resource with explanatory value.
Yeah, sure.
Can I add one?
Please, one final
comment
thing
there?
before we wrap up. Yes, sir.
Yeah, I'd like to echo Ilia's comments about the education and training for the prosecutor's office. And so listen here, I would say kind of 5 year, the US, we've been very active providing training to law enforcement and prosecutor's office. So for example, we have Aiken task force and the internet crime against children, which consists of say around 4,500 agents kind of working all together. And so they build kind of very strong technical training, series of training. And then of course, Bureau of Justice Assistant, they also providing similar kind of program type, working with academia and the private, and definitely kind of law enforcement office all together. So I would say, based on my assessment, it's been quite successful, because we're doing kind of pre-post test and a lot of kind of series of assessment for the training. And then we found that their kind of knowledge in the technical skill set and the legal and all of them kind of went dramatically. And so we're trying to kind of catch up the technology at this moment, but however, still, the new technology, right? And so like crypto investigation and dark web investigation, IoT forensics, and they are fairly new. Yeah, we talk about new era of technology, metaverses. And so these are very, very kind of advanced level. And so even those level, we trying to catch. So, and it's kind of, we making efforts on that. And hopefully those type of training kind of available to kind of entire world, and so throughout nations.
Thank you very much. I'm glad to, well, it is a pleasure. I can see that this has gone on for a much deeper discussion than the hour, and I have to pull it together now to close the session. This recording will be made available, and you will receive information about that. I'd like to express my thanks to all the committee here with their vast experience and contributing to this and sharing their knowledge. And every time I listen to this group of people and these people, I always learn so much about it. And I'm sure everyone here would like to express their thanks to all of you for drawing the important things to the attention and reminding us of things, and of course, introducing new topics. It is without doubt something that's facing our generation and future generations. And it needs more discussion, it needs more research. And I have to say, it needs more money as an input to find the solutions. So to wrap it all up, thank you to everyone that's come here today. If I didn't get to present your question, I'm sure you appreciate there's a limited time, and I hope that we can repeat this exercise soon. And of course, my thanks to Dr. Ilia that did a lot of the background organisation of this as well. So thank you all very much. And I think technical support will now close the recording and end the session.